A warm good morning and welcome everyone to today's workshop. Today we are presenting procedure of patent filing and commercialization of patents presented by Mrs. Preethi Narayanan. Just a little instructions before we get started. If you have any questions during the presentation, please type them either into the question box or chat box. We will collect them during the question and we will collect and address them during the question and answer session at the end of today's presentation. And two feedback links will be posted in the chat box. One is today's session feedback form and another one is overall feedback of the event. You are requested to fill both of the feedback form to receive your e-certificates. Now, I would like to invite Mrs. Vasugi, Deputy Director, International American Council for Research and Development, USA, to introduce our guest speaker of the day, Mrs. Preethi Narayanan.
Happy morning to all. I am very happy to facilitate. I am the Director of Indian American Council, Research and Development. Our organization is a non-profit organization. I am very much happy to introduce our chief guest today, Mrs. Preethi Narayanan. Mrs. Preethi Narayanan is a patent consultant from Chennai. She is a registered patent agent at Indian Patent Office and registered startup patent facilitator under Startup India scheme. Now I would tell about her educational qualification. Mrs. Preethi has completed her master's degree from Madras University. Further, she has completed postgraduate diploma in intellectual property rights from Indira Gandhi National Open University and postgraduate diploma in patent law from Nalsar, Hyderabad. Mrs. Preethi Narayanan is a patent consultant. She has more years of experiences. She has 10 years of professional experience, in that which includes 7 years of experience in the field of patents. She has vast experience in working with reputed law firms and in Center for Intellectual Property Rights, Anna University, Chennai. She has delivered lectures in patent awareness workshops at universities and colleges across Tamil Nadu, conducted by Tamil Nadu State Council for Science and Technology. Also, she has delivered guest lectures on patent at colleges across Tamil Nadu and delivered a speech at CIPAM FICCI 100 webinar series on intellectual property. As a patent consultant, she is providing full patent services from prior art search till grant of patent. Even though her area of specialization is in biotechnology, she has handled various technical fields such as pharma, life sciences, chemistry, electrical and electronical, mechanical, etc. She has handled clients from various domains, from academic to industry. She has experience in patent searches and patent analysis with working in patent databases. Thank you.
Now the session is over to Mrs. Preethi Narayanan.
Thank you for the introduction, ma'am. Good morning to one and all. Okay, I'll share my screen now. Is my slideshow visible?
Yes, ma'am.
Okay. So today in this session, I'll be talking about patent filing procedure and commercialization of patent. Okay. So before going on to know about about patent filing, we should also know about what is patent and basics about how to do a prior art search and a brief on specification. Okay. So first, I'll start with what is patent. Patent is an exclusive right given by our country to the owner of the invention to make, use, manufacture, or market the invention. Patent right is an exclusive right that implies Can others unmute it? Can all mute, please? Patent right is an exclusive right that implies no one can make, use, manufacture, or market the invention without the consent of the patent holder. And this patent right is for a limited period of time, that is for 20 years. After 20 years, your invention is in public and anyone can able to use it. This patent mainly protect your invention. So what the invention according to the Indian Patent Act is, it means a new product or process involving an inventive step and capable of industrial application. I was talking about patent, which gives a protection to your invention. So if you take this patent, patent would protect the mere ideas. So to be capable of patent protection, your idea have to be written down or drawn or otherwise embodied in an invention. That's why it is said that mere ideas cannot be protected. So in order to go for a patent protection, at least you should have done a prototype or a product, or if your invention is on a process, at least a lab work, wet lab or a dry lab work should be done. Because if you do that, you will get a very clear idea of the concepts of your invention. What are the main aspects? What are the embodiments of your invention? So if you do it practically only, you will get all these ideas, all these aspects. So that's why it said, patent don't protect the mere ideas. Okay. And what are considered for applying for a patent? A new component or an innovative product. Example, a new type of lid for a drinks carton which keeps the content fresh for longer. Next, an industrial process or a way of making or manufacturing something. Example, a new plastic molding technique. And a new apparatus or equipment used in an industrial process. Example, a new kind of tool for cutting metal. If your invention has a new product or a new process or method, a new device, apparatus or equipment, then you can go for patent filing. So before going for a patent filing, because patent filing is a time consumable as well as it is costly. Not so much, but it is a amount consumable. So in order to avoid these things, you should know whether your invention is patentable or not. For that, you should check whether your invention has three basic criteria, such as novelty, inventiveness, and industrial applicability. What is novelty? It should be new. It should not be published or known to or available to the public before the date of filing your patent application. Inventiveness. Your invention should have technical advancement or economic significance, or both with respect to the existing knowledge. So thus makes your invention non-obvious to a person skilled in that. If it is obvious to the person, then it won't come under inventiveness. So you should think in such a way that your invention should be non-obvious to a person skilled in the art. Okay. Next is industrial applicability. It should have some utility, usefulness to the society. Invention should be patented, have utility. It is capable of being made. As I said, the invention is for protection is for 20 years. After 20 years, someone, if they want, they should be able to manufacture it. So your invention should have some utility. Even after getting patent, after 3 years, you should also submit about working of the patent. For that, your concept should have some manufacturing capacity or some usefulness to the society. Okay. So these are the three basic criteria you should keep in mind. One is novelty, that is newness. Next, inventiveness, that is technical advancement or non-obviousness of your invention. Then third is industrial applicability or utility. Other than these three basic criteria, our Indian patent has given a non-patentable subject matter which is coming under Section 3 of Indian Patent Act. So what are the non-patentable subject matters? If your invention falls under any of these below categories, you're not allowed to go for patentable. Okay, so those concepts are not patentable. What are they more? Inventions that are frivolous and contrary to natural laws, inventions which go against public morality, inventions that are a mere discovery of something that already existing in nature, the mere discovery of a form already existing in nature that does not lead to enhancement of efficacy, mere admixture or mixtures leading in the aggregation of properties, mere aggregation or duplication of the devices working in a known way is not an invention. Horticulture or agricultural method, medical, curative, prophylactic, diagnostic, therapeutic for treating a disease in humans and animals are not patentable. Essential biological process for the production or propagation of animals and plants, simple mathematical formula or business method or computer programs, then aesthetic creations, mental act, rule or method of playing games, presentation of information, topography of integrated circuits, traditional knowledge, and atomic energy inventions, these are not patentable under Section 3 of Indian Patent Act. So you should also check whether your inventive concept is coming under any of these categories. Okay. So this is about checking for patentability. Next is, when should you apply for a patent? This is much important. Why I'm saying here is most of you are academic people. Okay, so when should you go for filing a patent application is, it's mainly decided, it's up to you whether to go immediately or to delay the process. So for example, you may wish to delay it as long as possible to prevent your competitors finding out exactly what you're developing. But if you suspect that a competitor is already working on the similar development, it is advisable to apply for a patent as soon as possible. Okay. And the second concept is, if you are working with any alliance, like if you are working under any scholarship or any programs like UGC programs or getting any funds, in such a case, before applying for the fund or programs or scholarships, it's advisable to go for a patent filing. Even though if you require time and money for proceeding further in your invention, you can protect your idea as a provisional specification. I will let you know what is the provisional later. At least as a provisional, to just you can protect your concept. By filing a provisional application, you can protect your scope so that others cannot be able to file the application on the same concept. Because sometimes without having a patent knowledge, you'll be filing your application, you'll be submitting for the scholarships or any fundings or any other combining programs with any other universities. Okay, so what they will do is they'll get your idea, and if they think it is valuable, without your knowledge, they may tend to file a patent application. So what will happen? You will be the loser. You cannot go and file the same concept. It's a very tedious process to fight and get the priorities, so many things. So in order to avoid such problem, if you have a good idea and you want to proceed further, before applying or disclosing to any other third party, you can disclose this to patent office, like filing a patent application, the provisional application, to get your concept protected. So you will have the priority date. You will be the sole owner. So no one can able to copy, sell, or produce your product without your permission. Okay. So these are the two main things that you should know. When should you apply for a patent? Because priority date is very much important in patent. So who is filing first will get the priority and get the patent protection. So that's why I'm insisting upon this. Okay. So I think question sessions we will handle at the end. If you have any questions, meanwhile, you can type it up as directed by the person. Next is how to analyze the patentability of your idea or your project. That is patent search or prior art search, novelty search. By doing this search, basically, you will come to know whether your invention is patentable or not, whether it is available in public, whether you are the first person to work on it, or it has been worked by somebody else and got the patent granted, or it is in the market, someone are manufacturing it. So what your competitor is doing, what the other college of the same department is doing, all the things you can come to know by doing the patent search. So what the patent search is, it is a wise and cost-effective process of all granted patents, published patent application, and non-patent literatures related to the subject matter of your invention. And why should you do the patent searches? The search is conducted to determine whether your invention is patentable or not. Then to what degree it is patentable. So what degree it is patentable in the sense, I'll say you a simple example. If you're working on a process, okay, and your invention has 5 steps, A, B, C, D, and E. You're doing the prior art search or patent search, and you have found out similar documents which cover the steps as A, B, D. So C and E are left over, no one had touched it. It's a new steps which have been incorporated to get the same product. Okay, so in this time, what you can do is you can do more and more research on this, how the C and E has been working, what is the reaction takes place, all the thing, what a catalyst use, if it is a chemical, what a catalyst use, all the things you can work on it. Then you can go and file your patent application with claiming mainly on C and E steps, but including all the 5 steps, so that it will increase the chance of getting patents. Okay, so for this main purpose, the prior art search is important. And to search any information or technology has been disclosed to public in any form about an invention related to your invention before a given date. Okay, so this is about the basics of what is patent search. And what and all should be analyzed in the prior art search. Granted patents, published patent application, scholarly articles, books and other published documents, daily newspapers, pamphlets, everything can be searched to get the prior art. Okay, so we saw what is patent search and what and all should be searched and how to conduct a patent search. So first, as I said, mere idea cannot be patented. So you should work on it. So once you work on your concept or a process, a product or a device, you'll come to know what are the main aspects. So first, if you do the practical, you'll come to know, you can understand the subject matter. Then you'll get the main aspects, main embodiments. So you can analyze the aspects of your invention. So by analyzing and writing down the main aspects, you can find out the keywords, important keywords. So identifying the keywords in the sense, for example, your invention is on a vehicle. Okay. So it may be a 2-wheeler or 4-wheeler or 3-wheelers, whatever it may be, amphibious vehicle, whatsoever it may be, it's a vehicle. You're using the term vehicle here. In maybe in US, they may be using the term directly as car. Or somebody in other country, they may be using the term transport facilitator, likewise transporting apparatus, or like they may be using. So in order to get all those relevant documents based upon your concept, what you should know is, once you find out the keywords, you should also know the synonyms. You should also find out the technical terms and also the common terms. which will help you to get very relevant documents. Because some may ask me, we are doing the prior art search and we are doing so for so long. When can we stop the prior art search to get the documents? So the only solution is if you know the exact keyword with all the technical terms, synonyms, common terms, then you will get the very apt 1 or 2 documents which will help you to complete your prior art search with the relevant documents. Okay, with the relevant information that you require. What is the current technology and where your invention stands. All these things you can easily get. Okay. Next, we have to go for prior art search using search tools. I'll teach you the 3 basic search tools which is available free and which are also helpful to you. Okay. Next is identifying the relevant documents, preparing report and differences. What is the result of this prior art? I was talking about prior art, do the prior art search to analyze the patentability. So what is the result of this prior art? An idea about which part or feature or embodiment of your invention is already covered and what could be the novel feature. That's why I said with the example, C and E is not available. That you can know only by doing prior art. It helps to focus on further research or development work to get maximum level of protection for your invention. Further, it gives a clear picture about whether it is appropriate to proceed with drafting the patent specification. Okay, so this is about prior art search. So I'll show you the tools: Google Patent, USPTO Patent Search, and Indian Patent Impasse. Okay, and I've used the common keyword vehicle. So what the Google patent says, first we'll see. Vehicle, when I click onto this vehicle, it will redirect you to this page where you will get the relevant documents. Okay, I got nearly 5 lakh document because it's a very common term. So you can further elaborate it term, like you can add it in this place, like in the synonyms, like electric vehicle, 3-wheeled, whatever the new concepts like amphibious, flying capacity. If you add terms like this, the results will come down. The numbers of the results will come down. You will tend to get relevant documents. Okay. And here also you can, if you want to know, search for a specific inventor, specific assignee, all these things can be done. So sometimes in this Google patent itself, it will show you which are the companies working on this. There is a graph in the right hand corner. You can see the graph. Okay. So that will also help you for any searching for any commercialization process. Okay. Excuse me. Right. So when I click on to this first one, method and apparatus for vehicle traffic control, I was directed to this page. It has abstract. It will give you the abstract. Images, you can zoom the images and see. Below the images, or left side, you'll get the description, and the right side, claims. Here in the right hand top, you'll get the application or the patent number. Which country is this? It is from United States. And download PDF option is also there, and including the bibliographic details, who is the inventor, who is the current assignee, and what is the patent family. See, worldwide application is here. Sometimes this patent has been filed other than India, other than US, like China or Japan. All these informations will be provided here. And application status, whether it is live or expired or abandoned or withdrawn, all the details will be provided here. Okay. And as it is in US patent, you can click download PDF and download the document. Okay. So you'll get this document. It's a PDF document which can be downloaded. But in case if it is a China patent, Korea, German, Japanese, so they will be filing patent application in their native languages. So only the translated version is available in Google. That's why I'm teaching you the Google patent, how to do search in Google patents. Okay. So if you click onto the download PDF, it will be in their native language. So it's very difficult to get English language. So in such case, to download, to get this document as a reference, you can cut copy in a Word document and use it for future reference. Okay. But still, in some case, you can check it out whether it is filed in US or Europe. Here in worldwide application place, you can check. If they have filed it in US or Europe, you can click onto that. That document will be open. From there, you can download the PDF. Okay. So am I clear? Any questions regarding this search? You can get back to me. Okay. So this is the PDF document. We will get it. Next is USPTO. Patents that are filed in US, originally in US and filed in US through PCT, all these patent documents you can search in USPTO patent search engine. So when you type USPTO search, you'll get this page where you can search for USPTO full text image and USPTO patent application. This is the granted patent and this is the published patent application. When you click onto this full text image, it will direct to this page and you can search for quick search can be done, advanced search, and if you know the patent number, you can do the search. Vice versa for this patent application, quick search, advanced search, and if you know the publication number, you can do the search. When I click onto this quick search, it will redirected to this page, okay, where you can go and search for the same keyword I have done here. What are the fields you can search is title, abstract, patent number if you know the patent number, and if you want to search for applicant name, inventor name, assignee name, all these things you can do the search here. Okay. Next is. So as it is very common term, I got nearly 8 lakh patent, but if you give some more terms, as I said, it's vehicle, electricity, three-wheeled, and automatic. So if you give so many terms, the number of relevant documents will be reduced and you'll get the very exact documents. Okay. When I click onto this first document, method and apparatus for accommodating device, it will redirect to this page where you can get the bibliographic details, application number or patent number, then title, abstract, inventor, applicant details, then any relevant US document, the priority details. Below that, you'll get the claims. After that, the description. All these things will be coming in the single page. Okay. And for getting a PDF of this, you can see this image available at the top end. It's not visible here. So if you click onto this image, it will redirect to this page where you can download the full text PDF and download this PDF and use it for your reference. Okay. So this is about USPTO. Next is Indian Patent Advanced Search Tool, where you can search for Indian patent documents, documents of your colleagues, documents filed by your college, all these things you can search here. So this is the page, Indian Patent Advanced Search System, where you can do the patent search. If it is a granted patent, you can check for patentee register. If you want to know the specifically any application status, that you can do in application status. Okay. And here in INPAS, you can search for only for published. Published it include granted also. If you specifically want for granted also, you can do the granted by clicking onto the grant. Okay. You can search by title, want abstract, complete specification. If you know the application number, publication number, or the patent number, if you want to search for your college name, college as an applicant, if you want to search if any of your staff or your student have done an invention, inventor name. So these things you can search. So here also I've used the same keyword, but when I click on to this published and do the search, I got nearly 12,000 document based on the vehicle. Vehicle is a common term, so I got nearly 12,000 published documents, which include the granted patents also. And when I take to this granted and do the search, I got nearly 2,000 patents. Okay, these are granted patents. Okay. So when I click on to this first one, it will redirect to a page where you can get the bibliographic details. What is the title? Who is the inventor? Who is the applicant? Abstract and XML version of complete specification. All these things you can get it out here. And down you can see the view application status. If you click to the view application status, so it will auto direct to this page. Or some communications, email and details, everything is there. And also shows the application status. This is the granted patent, so it shows granted application. If it is an examination stage, it will show request for examination file, awaiting examination. If you're issued response await, or it is in a grant application is in response has been filed, so hearing await. So all these status, what are the status, it will be available here. Okay. As it is a granted patent, you can see this e-register here. If you click onto this e-register, you'll come to know whether this patent is live or dead. This is mainly helpful for your commercialization purposes. If you want to proceed with this invention, in such a case, you can check whether it is live or dead. Then also the application number, who is the current assignee, who is the owner, and what is the communication address. And I said the patent, it should not be for a mere idea, it should be working. So working of the patents also should be submitted. So all the working of the whatever, how they have been working, they are manufacturing or not, all these details you can find it out here. And whether renewal, it is renewed or not, all the contents you can find it in e-register. Okay. Next is view document. If you click to the view document, you can get the document from day one. From the, if it is from provisional, the provisional document till grant. All the documents, all the communications to the patent office, everything is available here. You can download the PDF and use it for your reference. Okay. This is about prior art search and tools for doing prior art search. Okay. Next, I'll brief about what is patent specification. Before going for filing of patent application, you should also know what is the specification is. Just a brief. Patent specification is a techno-legal document. It has both the technical content and legal content. Technical content in the sense what you have done in your invention, embodiments, process, steps, everything. Legal is what you want to claim. The claim part is the legal part. You want to claim to get the protection. Okay, that is the legal concept. Okay. Patent drafting includes the detailed written description to replicate the invention and the claims where the invention is protected. As I said, the patent life is only for 20 years. After 20 years, it is available in public. So anyone like your student or your colleague, if they take and read your document, they should be able to replicate it. So you should give the specification in such a way that the best mode of performing your invention is clearly described. Okay, this is the patent specification. What are the types? So from the beginning, I was saying, if you want to protect, you can go for provisional specification. What is provisional specifications? Provisional specification is if you're working on a concept, okay, and it is taking time for you to get the report or get to, if you're working on any microorganism, it's taking time for the replication or duplication or providing the enzymes. Or if you're working on any missions, it will take time for getting the final product. In such a case, you can protect your concept or your idea by provisional specification. What the provisional specification gives is it will give you the priority date and it will protect your concept. But this provisional will not be published or examined further. And the life of this provisional specification is only for 12 months. After 12 months, you have to file the complete specification. That is, within 12 months, you have to file the complete specification. Because if you fail after 12 months, your application will be abandoned. Okay. And what are the contents that you can give with the provisional is title, field of invention, background, summary, and brief description of drawings. You can give the title, but what you should keep in mind is if you give title for this provisional, it should not be amended or changed in the complete. But if you want to change, there is a specific amendment form is there and you have to pay for that. That's why you should be very cautious while giving the title. Next is field of invention, background, summary, and coming to this drawing. If you know the drawings won't be changed after at the time of filing complete, then you can give the drawing. Because if you give one drawing here in provision, and if you want to change the drawing in complete, it's very difficult. Okay, so that's why I insist that if you're confident, you give the drawings. If you're not confident, you think that it may change at the time of complete, or it may change when you get the results or graph, then you don't need to give the drawing with the provisional. Only you can give the title, field of invention, background, summary with the main aspects to protect your scope of your invention. This is the provisional invention. Keep in mind this provisional life is time only for 12 months and it won't be published. So, well, if you have filed a provisional and you want to go for complete, you're referring the provisional to someone, don't give the application number alone because they cannot be able to view the document because it's not published. Okay. So this is about provisional specification. Next is about complete specification. Complete specification can be filed in two ways. One is after filing provision, you can file the complete specification, that is within 12 months. Okay. Next one is you can file the complete specification directly also. If your invention is ready, for example, you are having a device, you have worked on the device and the device is completely ready. And you have done practical working also. You have examples working of the device, everything you have it and ready, then you can directly go for complete. No need to go for provision, you can directly file the complete specification. Okay, please keep in mind, this is the question I'm getting from so many academic people, like whether they can directly go for complete. They can directly go for complete if your invention is fully ready. You don't want to take time for reports or results, then you can directly go for complete specification. And complete specification is a techno-legal document. The contents, the anatomy of patent specifications, it has title of the invention, field of invention, background, object, summary, brief description of drawing, detailed description of invention with reference to drawings, claims, abstract, and drawings if any. Okay. This is about patent specification. Two types. One is provisional and complete. Provisional will give you the priority date. It won't be published. It will help you to protect your concept. Then complete specification will be published. Then it will be examined and it helps to grant. So you have to disclose the best mode of performing your invention in the complete specification. So now we will come to the topic of this webinar. What is the filing of patent application? Who can file? So patent is coming under intellectual property rights. So it's a property. Property cannot be filed by anybody else. It should be filed by the sole owner. So it should be filed by the true and first inventor or true and first inventor assignee. To make it simple, true and first inventor is the individual who worked on the invention, and assignee or the applicant is the college. If you're working on a college, if you're a staff or a student of a college, on your behalf, your college as an applicant, they can file it. Or if you're an employee of a company, on your behalf, your company can file it. So true and first inventor, true and first inventors assignment. Okay. Where to file? As we are in Chennai, we can file it in Chennai Patent Office. It's depend upon the jurisdiction. How to file patent application? There are two modes: online filing and physical filing. E-filing can be done using the Indian Patent Office portal. In physical filing, you can submit your documents directly to Patent Office. Okay. So we patent agents will go for e-filing. Next. So while filing a patent application, you should also know which type of patent application you're going to file. Whether it is an ordinary, divisional, patent of addition, or which type it belongs. As we are discussing from the beginning that we are starting with an idea, doing the prior art search, then drafting a patent specification, then going for filing your patent application. Okay. So this is the first time you're going to file a patent application. In such a case, your application is an ordinary application because there is no priority or there is no reference to any other application. So such type of applications are known as ordinary patent application. Next is divisional application. For example, if you have filed a patent application, okay, patent application, the claims of a patent specification should be done for only one scope of invention. If it is more than one scope, it's not considered. So what you have to do is you can divide the patent application. Divisional application can be done by yourself willingly, or it may be done by the insist of the controller. For example, you are filing an application today and you find out there are two concepts. Then in such case, you can go for division of application, which will be considered as the ordinary application. It will also go for examination, all the things, and it will also get granted. And the time of division application is also 20 years from the date of filing. Next is patent of addition. An application which may be filed subsequent to filing of an application for a patent, improvement or modification. To make it simple, you are filing a patent you have filed a patent application last week. Today is Friday. Okay, last Monday you have filed a patent application, and this week you have done some modification or improvement to the same concept. For example, as I said, there are 5 steps in a process. Example, we'll take a process example. There are 5 steps in a process: A, B, C, D, and E. You worked further and found that there is another step called E1. You want to file that modification. In such case, instead of going for a new patent application, you can go as patent of addition. This is mainly done in case of pharma industry scheme for keeping their invention as evergreen patent. They will do modification, patent of addition, patent of addition. This type of patents, you can see the continuous patent in the form of continuous patent in US. So this is the patent of addition. Okay. This modification alone, you can go for a new patent that is known as patent of addition. Next is convention application. You are filing application in Indian Patent Office. Further, you want to go and file it in another country, like specifically you want to go in US and Europe, only 2 countries. In such a way, you can use this convention application. But you found out there is a scope in more than 5 countries like US, Europe, Japan, China, and Korea. So you want to file your patent application in all these 5 countries. Then you can choose the route called PCT, Patent Cooperative Treaty. It is an international filing system which helps you to file your patent in all designating countries. It is just a gateway for applying in other countries. It won't grant the patent. Okay. If you go through this PCT, there will be a compulsory international search report by the International Search Authority, where it will tell you whether there is what are the chances for getting patentable, whether your invention is patentable or not. It will give you a search report. And still you are not confident, there is also international preliminary examination report that also you can apply. You can get a final report whether your invention is patentable or not before going for your designating countries like US, Europe. And this PCT by itself, it will give 31 months from the date of filing, date of your priority filing, for entering into other countries. Okay, this is the PCT route. So there are 5 types of patent application: ordinary application, divisional, patent of addition, convention application, and PCT. Okay. What are the steps involved in patenting procedure? Filing of your patent application at patent office is the first step. Okay. Along with the complete specification, it is requested to file the filing of request for examination. It is advised to file, but it's not compulsory. You can file it within 48 months. Then your application will be published in Patent Office Journal, examination of application, pre-grant opposition, grant of patent, and post-grant opposition. This is the overall patent filing procedure in India. You'll be filing the provision within 12 months or filing the complete specification. From provisional filing date, within 18 months, your application will be published. This is the normal route of publication. Within 18 months, it will be published there where there is no fee. But you want to go for any, as I said, you want to go for any scholarships, or you want to publish your document in any journal, or you want to go proceed with any higher studies, or you want to attach your document with the resume. So in all these cases, you can go for early publication, where your application will be published within 1 month from the date of filing. Okay, so there is a specific fee for that. You have to pay the fee with the request form. If you do that, your application will be published within 1 month. Okay, next is from publication, then examination. Actually, the request for examination can be filed within 48 months. It is a compulsory form that has to be filed. Otherwise, your application will not be examined. But if it is advised to file along with the complete specification so that your application will come into queue. It will be examined soon. Okay. From the date of publication till grant of patent, your application will be open for pre-grant opposition. Okay. Then examination, technical examination, then substantive examination, both will take place. Technical examination in the sense your invention, technically whether it is patentable or not, all these things, novelty, all the 3 basic criteria, including the non-patentable subject matter, will be examined. Substantive means like forms. If there is any discrepancies in the forms, all these informations will be given. Then first examination report will be issued. It has to be replied within 6 months from the date of issue. So you have to file the response to FAR with all the required document. So you can put it for grant. If there is any no other issues, your application will be granted. If anything required, they will call for hearing. After that, grant of patent. From the grant for 1 year, your application will be open for post-grant opposition. Okay. This is the overall patent filing procedure in India. Next is, what are the requirements for filing an ordinary patent application? As I said, patent is a techno-legal document. So we have to provide both the technical informations and legal informations. What are the legal forms? Is Form 1, the basic main form, application for grant of patent, where you will be given the name and address of the inventor, name and address of the applicant, communication details, information corresponding to any prior patent applications, all the things will be given in Form 1. I'll show you the form 1 later. Along with that, if you're filing a complete specification, what are the basics form you have to do is form 1, then form 3, where you'll be giving the details about foreign filing. If you're going through any PCT or any convention application, all these details timely you have to intimate to the patent office through form 3. Okay. Till grant of patent, you have to intimate. Next is form 5, declaration of inventorship. Next, form 18, request for examination. It should be filed within 48 months. So the patent office will not consider the application for examination unless this form is filed. Okay. Then form 9, request for early publication. If you want to publish it within 1 month, you can use that form. Otherwise, your application will be published in 18 months. Next is form 26. If you are filing to agent like us, you have to provide a power of attorney in non-judicial stamp paper. Okay. Next, if you are claiming for any startup or small entity, then form 28 to claim your status. These are the legal forms where you are giving the details. Next is technical form. Form 2 is the technical form in which you will be giving the complete details about your invention, field of invention, background, object, summary, description, and the legal part, claim, abstract, drawings. All these things will be providing in form 2. Okay. So summary will say that what are the documents required for filing is application for grant of patent, form 1, provisional or complete in form 2, statement and undertaking, that is about foreign filing in form 3, declaration of inventorship form 5, request for early publication in form 9, request for examination in form 18, power of attorney in 26, to be submitted by small entity or startup in form 28. Other than this, if there is any other communications, any agreement deed or assignment deed, or anything you want to communicate to the patent office, if there is no forms available, you can use the form 30. Okay. So these are the forms. I think you can see this form. This is form 1. Okay. Type of application, as I said, you can choose the application here: ordinary, conventional, PCT, ordinary, divisional, or patent of addition. So you can tick accordingly. Have to give the applicant name. For example, your college, you have to give the college name and full details. Category of applicant, natural person. There is a category for mainly for the fee. So if you go as a natural person, you're filing individually in your name, you will be considered as natural person. Small entity or startup. And if you're filing in the name of your college, that is the legal entity, so it will come under, have to tick others. Okay. Then all the inventor's details you have to provide. Okay. Title of the invention. And next, if you're filing agent like us, we'll be giving authorization details, all the details, and address for service, that is the communication address. Other than this, if your invention is coming from a convention, this is not that much needed. Conventional application or PCT. So all these particulars, divisional application, patent of addition, all these particulars you have to fill in, if any. Okay. Then declaration by the inventors. This should be signed compulsory, even though the inventor and the applicant are the same, it has to be signed. Okay. Then what are the pages? Details about form 2 should be given here. Number of pages of complete or provisional. If it is provisional, no claims, but if it is complete, number of claims, number of pages, and abstract, number of drawings, all these details you have to furnish here. Okay. And the payment, how you are receiving the payment. And here we have to also provide what are the forms you have been attaching. Form 3, Form 5, Form 9, Form 18, all these details you have to provide here. Next is fees, how we are emitting the fees. All these details you have to give. This is about Form 1. Okay. Next is Form 2, title, applicant details, and it has preamble. If you're going for provisional, the preamble will be the following specification describes the invention. And if you're going for complete, the preamble will be the following specification particularly describes the invention and the manner in which it is to be performed. Okay. Next is Form 3. The same thing, you have to give the applicant details and communication address, the applicant address and signature. Okay. Form 5, applicant address, including the inventor, complete details of how many inventors are there, all the details you have to provide. This is Form 5 for the declaration as to inventorship. Form 9, request for early publication. And Form 18, request for examination. Here also you have to provide the details, application number, address for communication. So all these things you have to give in Form 18. This is the power of attorney. It has to be provided in stamp paper. And Chennai, we are using 100 rupees non-judicial stamp paper. Okay. So this is about the forms and the patent filing procedures. Okay. Next is the main question. If you want to file a patent, the first question will come to mind, how much fees I have to pay. So patent office fees. I have given the fee structure for e-filing. Okay. If you're filing in your name individually, and if you're a startup or a small entity, so the fee, total fees will come along around this 8,100, which includes the form 1,600, request for early publication 2,500, and request for examination 4,000. Okay. But if you're filing in the name of your college as a legal entity, the fees will come around nearly 42,000. It includes the form 1 for 8,000, request for publication 12,500, and request for examination is 20,000. Okay. And if you're directly filing with patent office, physical filing, there is an increase in 10% of fees. Like if it is 1,600, it's 1,750. 8,000 means 8,800. 10% increase will be there. Okay. This is the main difference between e-filing and physical filing. They have increased the fees for 10%. Okay. This is about fee structure. Okay. So finally, I would like to touch about commercialization of patent. Okay. So before that, I'll summarize what and all we saw in before. Like we'll start with idea. We'll talk. What is patent? Patent is an exclusive right given to the owner for making, using, or manufacturing the product. Next, we saw about patentable criteria such as novelty, inventiveness, and industrial applicability, including the non-patentable subject matter. Then we saw what is patent search, prior art search, which will give you the idea where your invention stands, whether you can proceed further in filing or whether you can proceed further in research. Okay. And we also see the easily available free tools for basic prior art search to get an idea that can be done even before starting your projects or your PhD thesis. If you have an idea, like you're thinking that I want to work on monoclonal antibodies. If you have an idea, you can do this patent search to get an idea whether that is available, what is the current technology, where you can work. For that also prior art search is important. And we saw the tools. After that, we saw the patent specification, two types of specification, provisional and complete. Then we saw filing of patent application procedure, starting with filing, request for examination, publication, all the requisite forms, compulsory forms, technical forms and legal forms we saw. Then finally, we saw the fee structure for e-filing, and also we saw the types of application like ordinary application, divisional, patent of addition, convention, and PCT. Okay, am I clear? So finally, I'll be talking about the commercialization of patent. while talking or discussing about the prior art search itself, I said that Google, even the Google patterns will show you the graph, which are the countries are working on the same concept, manufacturing the same product. So if you do the prior art search itself, you'll come to know which country is keenly involved in the technology. So that will be helpful if you're going for a commercialization or licensing or claiming for any royalty or planning to sell your patent. Even that prior art search itself is very helpful. Commercialization is the process or cycle of introducing a new product or production method into the market. Technology commercialization is the process of introducing a new product or system into the market using new or improved techniques or tools. Steps leading to commercialization are first and foremost is the evaluate your idea. Is the invention novel? Then is that has manufacturing possibility? Can it be protected through patent? Is there a market for that? Market analysis you can do. How large is the market? What is the competition? Who are the competitors? Who are currently in the field? How far is it from becoming a product? How you can do the research? How you can manufacture your product? Who will help you in manufacturing this product? Or who is ready to buy your product? If you have a patent for a good device, who is ready to buy your device? Who can buy it? Who can manufacture it? Because most of you academic people, you will be having a good device, but you may not able to manufacture it or bring it to the market. So you can get companies help. You can seek for this company. You can do the market analysis. You can search for the technology which company is working on the technology. So you can communicate with them for commercialization, for selling or licensing. So you can do that. Or these resources to further strengthen, demonstrate, and refine the invention. So these things you can do before going for commercialization. Next step is protecting your idea by filing a patent application. Then you will obtain the status of patent pending, which will help you to proceed further. So if you are giving your device for someone to work on it, as an example, as a training or free sample, you can, if you first file a patent application for the same device, you can put patent pending. If it is not granted, till grant, you can put patent pending and give to them. Because without your concept or without your consent or your permission, they cannot able to produce it. That's why patent is very helpful. So you can put patent pending and give it to them. Then finding partners to develop this protected invention into products. Making presentation, conferences, companies, VCs, you can give presentations about your device or process or product. Then prosecuting patent applications, giving the details of your patent applications, identifying a licensee or a company or a buyer. If you don't want to license, you can sell your invention, or you can license it, or you can give for any royalty. You can go for two to three licensing also. So these things can be done. Finding financing for further process. If you, for example, if you're applied for a patent for Part A and Part B is there, so you can use this Part A to get further finance to do process research in Part B. That can be done. And negotiating license agreement. Okay. So this is the overall thing for commercialization. Identification of intellectual aspects, R&D grants and contract, discovery invention, accessibility of protectability, evaluation of commercial potential, and protecting by patenting, decision to commerce, you can idea created, you can license it, or existing company, you can do the search for the commercialization purpose. Okay. So this is the commercialization aspects of your invention. Okay. So in this session, we saw about the patent filing procedures, and a brief about what is commercialization. Okay. So this, I end my session. Thank you so much. So have any questions, you can ask.
Thank you, ma'am.
Thank
Now
you. The
we are-
session is now open for questions now.
Yes. So now we are going to begin answering the questions submitted during today's presentation. As a reminder, dear participants, you can still post your questions into the question box at chat box. The first question is, where can we apply for probational basis? Is there any specific government-owned department for the same, ma'am?
You can apply with patent office, right, for filing your patent application. Yes.
Yes. The next question is, ma'am, what is the difference between Indian patent and Australian patent?
Got this question few days back with one more seminar. See, Indian patent is one where we are filing in Indian patent office. It's just like that they are filing in Australia patent office. So there also your application will be examined, publication will be there. All these steps will be going on both in India and Australia. That's it.
Next question is there any protection for the new products?
Yeah, you can go for patent filing. No? It will give you the best protection. Your product will be protected through patent. Yes, next question.
Yes, thank you. This research comes under patentable criteria and in what extent?
Research. I can't get the question.
Is there, sorry ma'am, this
Yeah.
research comes under patentable criteria and in what extent?
Research is not coming under patentable criteria because see, you are not going to protect your research. You're going to protect the product or process or the final result of your research only. So it won't come under patentable criteria. So you're going to protect your product or process which you got through the research. Okay, so the question itself is somewhat difficult. Yeah.
So one participant said that I have applied a few patent in Malaysia. It's getting delayed there. Is there any possibility that I could publish them in India the same or with a bit of amendment? Is that possible?
Yeah, thing is, you're filing it in Malaysia. You have to check whether Malaysia will come under PCT, Patent Cooperative Treaty. Okay, but you have filed within 12 months. You can enter PCT and file the same publish the same application in India. Otherwise, you can have to file a new application only because within 12 months only you can go for PCT. Otherwise, you have to file for a new application because the PCT timeline will be dead. So you have to go for a new application you are filing in India. So check whether what is the date of your priority, whether it is coming within 12 months. Okay.
Yes, thank you, ma'am. The next question, can you give some examples regarding patent for commerce academicians? Hence, what will come under commerce related patent?
Commerce, I'm not aware of commerce. Any subject matter, if you say, I can say whether it is patentable or not, but I'm not available commerce.
The next question, what is the difference between trademark and patent?
See, trademark will give you, for example, if you're having a company, okay, company like Pfizer. Pfizer is a company. The name of the Pfizer can be protected through trademark. And the tablets which are produced by Pfizer, the formulation of the tablets can be protected by patent. So this is the difference between trademark and patent. Okay. Yes, am I clear?
Yes.
Yeah.
The next question is, what should be the best way to apply for the patent? Should it be directly by candidate or through patent agent?
It's up to you. See, if you go through patent agent, we will increase the chance of getting patents. Okay. If you file individually by yourself, you will get stuck at the time of examination. So because we are seeing so many people studying at the time of examination and coming to us. So if you go through agent, it will be there will be chances for getting patent will be increased. We will guide you in such a way. Yes.
Yes. The next question is, should the title of the patent be specific, including the name of the method and material used?
Should actually the title should be covering the technical concept, name of the method or raw materials used. All these things cannot be given within 15 words. It should be there, and it should cover. For example, it's a your invention is on a making tea. Okay, so your title should be process of making tea. So the raw materials used for making tea and all you don't need to give. Process of making tea it should be simple and technical, or it should express what their invention is. This is about the title should be. Okay.
The next
Yes.
question, is it possible to extend patent protection?
No, it's for 20 years, but you can go for patent of addition evergreening. So this is the it's a big concept, but the patent protection is for 20 years.
So next question, in management subject, any patent is there, ma'am?
I don't think so. I don't have any idea about management.
Yeah, I think we have covered all the questions. Participants, do you have any other questions?
Someone
Yes,
is
there is
raising
another
hand.
question. Yes, ma'am. Can
Yeah.
you tell us about copyright?
Copyright is different from patent. So for like you have some mathematical formula, writing a books, those can be protected under copyright. Drawing pictures and music's lyrics of a songs, these things can be protected through copyrights. Okay.
And the next question is, the process of rural development with the help of microfinancing patentable?
I don't think so. This is coming under patentable, but I cannot give the blind suggestion.
The next question, how can I tell if my invention is patentable?
That's why you can do the prior art search. Doing the searches, you'll come to know.
And the next question,
Yeah,
is patent applicable to social science?
social science patent is I'm not aware of it, because usually the science and technology will go for patent, because the patent basic concept, it should be have some technical advancement. It should be non-obvious to a person. Okay, social science and things should be mostly obvious to a person. So I don't think so it is possible.
The next question is, how the patents are examined? How many members will be in the examination board?
See, it will be examined by the patent examiners and the report will be given by the controllers. So it's mostly with the patent office. Okay.
Participants, any other questions?
I think some are raising their hands. They can unmute now.
Participants, do you have any other questions?
If anyone has question, you can unmute it and ask them.
I think we have covered all the questions. Thank you. So thank you very much, ma'am, for the extraordinarily wonderful presentation on patent filing procedure and commercialization of patent. It was incredibly informative and effective. We have learned a lot from you, ma'am, and look forward to learning more from you. On behalf of our institution, I express my heartfelt thanks for accepting our invitation and answering all the questions raised by our participants. Dear participants, 2 feedback form links are posted in the chat box. Those who have not filled it yet, kindly fill up the forms. Now, as we come to the end of the 3 days international virtual workshop, I like to call Ms. Vinolin Sylvia, researcher, AMET University, to propose the vote of thanks.
I deem it an honor and privilege to propose the vote of thanks as we draw curtains to this 3-day workshop. I'd like to quote a few words of Helen Keller. The best and beautiful things in the world cannot be seen or even touched. They must be felt with the heart, and gratitude is one such pleasant thing. First and foremost, I thank God Almighty for His abundant grace and blessings on all of us. I express the sincerest gratitude to our Honorable Chancellor, Vice Chancellor, and Registrar, who by their unwavering and ceaseless support empower research in our institution. My profound and heartfelt thanks to the Director of Center for Research, Dr. Rajashekar, for all his untiring and fruit-bearing efforts. I express my appreciation to all the speakers and especially to the guest speaker of the day, Mrs. Preethi Narayanan, for sharing a piece of her mind with us to enhance our knowledge on patents. Thank you for detailing on the types and procedure of filing patents, ma'am. You made it an extremely beneficial session. Thank you. A special thanks to Dr. A. Dinesh Kumar, Dr. D. Arivalagan, and Dr. S. Pungavanam for excellent organization of this event. I also wish to thank Mr. Bala Subramanian and Mr. Manoj, who backed us with their technical support. And I'd like to acknowledge all the heads of various departments and the faculty for their support and aid. Finally, a big thanks to all our dear participants. I hope this workshop has enriched your minds. I once again thank one and all here. Thank you.